Welcome to this free immigration help channel. Today is July 19th, 2024, and we are getting into the volume 223 of me answering your immigration related questions. As always, before beginning this video, I'm going to mention, as I mentioned in every video on this channel, I am not an immigration attorney. This is not legal advice. All the information provided in these videos on this channel are directly from official government sources like USAS and of course Department of Homeland Security, Department of State with their visa bulletin. So let's start with the very first question from Basir Kashani 2162. Hi sir, my priority date is 29 December 2017. Visa category F2B. Place of birth Afghanistan. Interview location before was Islamabad. I changed to Kabul. My mother got citizenship. Should I switch to F1 or remain in F2B? Give me advice. Thanks. Basir, that's a great question. Thanks for asking. So first of all, let's take a look at the visa bulletin. See what's going on in your case. So currently you're in F2B. Your priority is December 2017 chargeability area Afghanistan. So you're in all chargeability area. So if we look at the visa bulletin on the graph A, first of all, to see how long before the availability of the immigrant visa, F2B for all chargeability area is on May 2016, and you are in December 2017. So May 2016, December 2017, that is about, so May 2016 to 2017 is a year, and then May to December, another roughly 6 months. So about a year and a half before the availability of the immigrant visa. So I'm assuming that you are either possibly just now documentarily qualified or getting there. So let's take a look at the graph B and see what about your documentary qualification. So currently F2B is on January 2017 and you are December 2017. So they are on January 2017 and you are in December 2017. So you might not be documentarily qualified yet. You might still have about 10-11 months before your NVC portal opens up. Again, it's not a definitive because a lot of times I have seen NVC portals, it's not as reliable, the graph B as the graph A, the availability of the immigrant visas, because graph B follows the graph A, and a lot of times it does not update as fast as the graph A does. So you might be already documentarily qualified, but most likely you are not yet. You still have about 10-11 months before the NVC portal opens up. So now let's take a look at F1 and see what's going on. So right now F1 is on October 2015. So F1 right now is actually, let's see, so they're still on 2015 and F2B is already on 2016. So F2B is, let's see, October, November, December, January, February, March, April, May. So F2B right now, as of right now, is doing 6-7 months better because they are 6-7 months ahead of F1. Let's take a look at the graph B and see if it's the same case for graph B. So F1 is on September 2017 and F2B is on January 2017. So F1 is doing better on the graph B. So that means that people in F1 are becoming documentarily qualified sooner than F2B. But their availability of the immigrant visa seems to be better for F2B than F1. Now you kind of see the dilemma. That's why I said it's a great question, because it is really at the end of the day a gamble. I cannot tell you how many times I've seen people staying in F2B, F1 doing better. Or other cases, switching to F1 from F2B, because you can do that. Once your parent becomes a US citizen, you technically have an option to either remain in F2B or switch it to F1. And a lot of times NVC themselves, they send you an email saying, hey, we see that your parent became a US citizen, you have an option to switch. So if they don't, you can reach out to them and request a switch. But at the end of the day, it is a gamble. So it's completely up to you. If you want to, I mean, you can, and as you can see, you might get your portal, NVC portal open up sooner than in F2B if you switch to F1. Approximately what? September, October, November, December, January. About 4 months sooner, which is great. But then you are looking at a longer wait time for the availability of the immigrant visa because F1 is doing worse as of right now. Again, next month, August, we might look at the visa bulletin and see that F1 is doing better than F2B, because there was time not too long ago that F1 was doing better than F2B. But again, we really don't know. So I would recommend, because you still have some time, I would recommend give it another few months. Keep paying attention to the visa bulletin, the next 2-3 visa bulletins, see what's going on. If it is the same situation just like it is right now, honestly, I would remain in F2B, because F2B is doing significantly better, about 6-7 months less for the availability of the immigrant than the F1. Start preparing for your documentary qualification, because it is pretty soon, and I think it is a lot more important to concentrate on becoming documentarily qualified. But if you see significant movement for the F1 in the next few months, you have an option to upgrade. So don't rush with that decision. I think it would be the best advice that I could give you. Don't rush with that decision. Give it another few months. Pay attention to the visa bulletin. Start preparing for documentary qualification, because it's coming up pretty soon. All right, let me post a response, and we're gonna move on to the next one from Sakshi Sharma KJ9ZQ. I got the information on I-94, but it just shows dates and just written arrival, top to bottom, not departure. I need full information for my travel. Can anyone please help? So Sakshi Sharma, so the issue arises when the records are not pulled up, and it seems like upon your arrival, the information was entered correctly. But the issue arises when the information is not entered correctly, and the system seems to be very, very sensitive. If there is one minor mistake in the name, in the passport number, in whatever, it's not coming up in this online system. At least that's the situation that has been for the past however long this online system have been around. It is very sensitive. So the issue seems to be that the information was not entered upon your departure, and that's why it is not coming up. So the best thing you can do is to reach out directly to Customs and Border Protection, and in this video I describe on what to do if either the whole information is missing or some of the information, like in your case, on your arrival departure record. Reach out directly to the CBP. They have the online form. If you cannot wait, if it is urgent, give them a call and let them know that, hey guys, listen, this is arrivals coming up, departures not coming up, and they're the only ones who will be able to help you and get that record pulled up. All right, so let me post the response, and we're gonna move on to the next one from Umair Parrot 515. I live in Pakistan. My internet is next month. Okay, I'm assuming your interview is next month. My age is 24. Okay, so my visa is approved, yes or no? Okay, so I'm assuming, because you're asking the question on the visa bulletin for August 2024, that you are in one of the family preference categories, possibly derivative beneficiary on your parents' case. And now that you're 24, you're asking whether or not you will be able to get your immigrant visa as a derivative beneficiary. So Umair, what you need to do, you need to concentrate on calculating your CSPA age, your age under the Child Status Protection Act. I do have a video on this channel. It's called CSPA, Child Status Protection Act. What does it mean? Something along those lines. If you just look on this channel for video labeled CSPA, Child Status Protection Act, it will come up. So what you need to calculate, you need to concentrate on 2 dates and calculate the period between these 2 dates. The first date is the priority date of the case that you are on. And the priority date is when the I-130, the initial application for the family reunification, was accepted by USCIS. That's the priority date. The second date is when that I-130 was approved by USCIS. Not the documentary qualification, not availability of the immigrant visa, not any other date. But when the I-130 was approved by USCIS. So it is only within USCIS processing from start to finish. And for different cases, different family preference categories, it is going to be different. But if on the day of the availability of the immigrant visa, if that period of time that we just discussed, that we just calculated, if you subtract that amount of time that the I-130 petition was pending from your age on the day of the availability of the immigrant visa, and if it brings the age down under 21, under CSPA, you are still a child, and yes, you are eligible under CSPA to receive your immigrant visa. That's why it is so important to find those two dates and calculate the difference between the two. It is very possible that, so if you are 24 now and your interview is next month, if that period of time is longer than 3 years, then you are good, because it will bring you down under 21 on the day of your interview. This is at the discretion. I have seen this situation go both ways. Officially, it is on the day of the availability of the immigrant visa. But a lot of times, and I have seen personally, where even when it was on the day of the availability of the immigrant visa, when the petitioner, when the derivative beneficiary goes for an interview, the person who takes the interview, the consul at the U.S. Embassy, they don't like it. They want it to be on the day of the interview, the CSPA. So calculate, that's very important. Calculate between the period between those 2 days, subtract it, and you will get your answer whether you will be able to get the immigrant visa or not under CSPA. All right, let's move on to the next one from Kevin TV7. Very, very clear and supportive. Dear, I appreciate you. Thank you, Kevin. I'm glad this was helpful. Only one question on part 5. If I am filling it out by myself, can I just leave that without checking either of them? That is the only what you did not mention. Thank you so much, dear. Just keep it up. All right, Kevin, thank you for your question. Let's take a look at the 765 application and see what's going on in the part 5. I'm pretty sure that's the certification by someone, by the preparer or the attorney, but let's take a look and see. So I-765, I'm gonna open it up in a new window. Let's scroll down to part 5. Okay, so contact information, declaration, and signature of the person preparing this application, if other than the applicant. Okay, great question. So just put the preparer signature once you print it out. Just put in the signature and in the date. Not applicable. You don't want to leave blank spaces. But yes, even if you do leave blank, a lot of times the part 5 is not going to be. But to be on the safe side, I would still put not applicable NA. Once you print it out, you can put not applicable here if you're filling it out on the computer, and because you cannot put anything in the signature, once you print it out, just write it in. When you will be signing, because you will be signing it anyway, in the part, let's see, I think it is part 3. Yeah, part 3 applicant signature. You will have to print it out and sign it anyway. But with all of that being said, Kevin, this form is the I-765 application for employment authorization is available to file online, which makes the process a lot simpler, a lot faster, a lot less potential for mistake. So if you can, I would highly recommend filling it out online, which is different from filling it out on the computer and then printing it out and then mailing it. No, when you fill it out online, you're doing it through USCIS online profile, and once you pay the fee online, which again, it's a lot easier to make a payment because you don't have to send a check or authorization form for a credit card, so far so forth. So yeah, if you can do that online, I would highly recommend doing that because it makes the process a lot more simple and a lot less potential for mistakes compared to paper application. All right, let's move on to the next one. Looks like again the question on I-765 video. Yemi Michael 6376 says tried sending form I-765 to the address meant for replacement of lost card which is USCIS Lee Summit production facility. Attention, I-75 plus car product Lee Summit. But the USPS agent told me the address is not recognized of their system at the post office. Okay, so let's double check the mailing addresses for I-765. Can be something on USPS side. It can be that they recently moved to a new maybe not a new address, but they recently moved, and that's why it's not being recognized at USPS. Possible, but let's take a look and see where it should be going. So we are looking for where to file, filing locations for I-765. So replacement, are we doing it for card error? So you're doing for lost card. Okay, let's see if there's a different one for lost, but right now this is for the replacement. Let's see if there's anything separate for a lost card, a refugee, categories, foreign students, eligible, family based, if you have pending, current, former, deferred action, parolee, other categories. Nope. So looks like this should be for lost, stolen. Let's see. So you need to replace a card we issued to you because it contains incorrect information that is not due to a USCIS error. You need to replace a card we issued to you because it's due to. So in your case, it is simply lost. So possibly due, not due to USCIS error. And this is what the address is showing us. Actually, it doesn't even matter because both of these are showing up for, it's the same address for both situations. So I don't even know why they have whatever. USCIS Lee Summit production facility, attention I-765, the replacement car, 7 product way, Lee Summit MO64002. 765 replacement cars, 7 product way, Lee Summit MO. Yep, so you got the correct address, Yemi. So it has to be something on USPS end. But yeah, you should be good to go with that address. And I'm gonna put this, and we're gonna move on to the next one from Francisca Antonio 7937. Hello, thank you so much for posting videos about that. The video is so clear and help a lot. Francisca, thank you for your feedback. I appreciate that. I'm glad this was helpful. Moving further to Furquan Mohsin. Sorry if I'm mispronouncing the name. 4514. Hello, my question is regarding CSPA. Will my age freeze when my priority date becomes current? Great question. I'll be 23 this month. Filed under F3 category in January 2011, approved in January 2015. For instance, if I am well under 21 considering CSPA, but age out before an interview is scheduled, is my age frozen as it was under 21 when priority date become current in chart A? Excellent question, Furquan. Thank you for asking. So this really never came up on this channel, but this is a great question. So officially, if we look on the CSPA definition from the official government website, U.S. Citizenship and Immigration Services, according to the CSPA Act, and I'll pull it up exactly, for the family, CSPA for family, preference categories. Age at the time of visa availability. The date the visa is considered available is the later of the two dates. The date the petitioner was approved, which in your situation is not applicable because the approval only comes in whenever it comes to immediate relative categories. Or the first day of the month when USCIS considers a visa available for filing an adjustment of status application. All right, so these are the two dates. Unfortunately, whenever you're going through the interview, this can be interpreted two different ways. One is on the day your immigrant visa is available under the visa bulletin. So as soon as the visa bulletin comes out from the Department of State on the first day of the month, that's it. So technically your age should be frozen on the day the immigrant visa is available, which is technically supposed to be judged by the visa bulletin, all right? Because that's what graph A is showing us. When the time in line when you are getting to the availability of the immigrant visa. However, I have seen it quite a lot of times. Unfortunately, the US Embassy they determine the availability of the immigrant visa when they themselves issue that immigrant visa, which is typically on or a day, 24, 48 hours within the interview. So their actual issue of the immigrant visa, not the availability of the immigrant visa, but the issue of the immigrant visa. So when they actually place that 551 stamp in your passport, and you see how many different problems it creates, because a lot of times, especially now, we have quite a significant difference between the date of the availability of the immigrant visa based on the graph A on the visa bulletin for family preference categories and when the interview is actually scheduled, because a lot of US embassies on average is about a year people are waiting for the interview to be scheduled. Some US embassies, they're not as busy, so people are getting their interviews much faster. Some are even more busy, like for example in Islamabad US embassy, they're really busy. Manila, Philippines, they're like 2.5 years wait time after the availability of the immigrant visa. And people are having the issue exactly like yours. So that's why I always recommend, whenever you're calculating the CSPA age, take into consideration the actual interview date. If you have to wait another year for the interview date, take that year into consideration and make sure your CSPA falls and takes into account that year that you're waiting for the interview, if that makes sense. So with all of that being said, Furquan, it's very important for you to calculate. So your priority date, you're in F3 category, your priority date is January 2011. Approved in January 2015. Approved, I'm assuming, by USCIS. So if it is really by USCIS, and we are not talking about documentary qualification, we're not talking about any of that, we're talking about I-130 received on January 2011 by USCIS and approved by USCIS on January 2015 and then transferred to the NVC and whatever else, we don't really look at it for now, for the purposes of this one. You have 4 years that you can subtract under CSPA technically on the day of the availability of the immigrant visa. But you're way safer to subtract on the day of the interview, just to be on 100% on the safe side. So you'll be this month's 23. So you're 23. Let's see. Let's take a look now when the priority date becomes current. Let's see. So you're F3 and you are January 2011. So F3 January 2011. So right now it is on April 2010, which means that if the visa bulletin is moving 1 month every month, you have about April, May, June, July, August, September, October, November, December, January 2011, about 9 months. All right, about 9 more months. So you're 23 right now. So even before you're 24, technically the immigrant visa should be available. All right. Now, depending on where you are in the world, depending on how busy US Embassy is there where your interview is going to be, on average, like I said, it's about a year. So add additional year. So you have about 10 months and then you have another year. So roughly a year and 10 months before the actual interview. Again, it can be a lot sooner than that. The visa bulletin might move a lot faster, and your interview might be scheduled in 4 months, in 6 months. Possible. So, yeah. But it might be longer than that, depending on where you are in the world, depending on how busy US Embassy is. But if we take a year, 10 months, a very rough estimate. Right now you're 23. A year, another year, you're going to be 24. Another 10 months, you're just over 24, all right? You're not 25 yet, you're just over 24. Let's say 24 and 10 months, okay? You have 4 years that you can subtract from your age. That's on the day of interview that we're calculating. because we are calculating, we're taking into account the whole year that you're waiting for interview as well, which is gonna bring you to 20. What you'll be 23 this month, and then 24, and then 24 and a half. So 24 and 10 months roughly minus 4 years that you can subtract under CSPA, it brings you under 21. Pretty close, but you are still under 21. So you're good to go. So hopefully it doesn't take any longer than that, because you see how really it is pushing very, very close. So honestly, in your situation, I would recommend to, first of all, definitely stay on top of the visa bulletin. Every month the new visa bulletin comes up, you should be the first person checking it and seeing if it is moving for the F3 category, and hopefully it is. Hopefully it is moving for everyone, but for example, this August 2024 visa bulletin, it was not very good for most of the categories. So keep checking the visa bulletin. And be prepared to, because it's pretty close. I would do some research and ask around, depending on where you are in the world, if you can, if you have maybe friends, relatives, or if there is like a public forum for people who are immigrating from your country, where you can ask around and see how long people waited approximately for an interview. Because if the interviews are typically scheduled within a year, you really are pretty good. You don't have much to worry about. But if the interviews are taking, like Manila, Philippines, for example, 2.5 years, that is, something to keep in mind. That is potentially going beyond, and you might age out. So hopefully this helps, and I really hope that under CSPA you can be good to go. This is the tricky nature of the CSPA. Honestly, I wish it would just freeze once the petition approved and that's it. But unfortunately, it's not the case for family preference categories. All right, let's move on to the next one from Vera Dole. Hey sir, I have been waiting on my pending DACA case submitted 7/26/2021, and literally my USCIS case tracker didn't update until a month or so ago that I was approved. Oh, nice. For the same DACA process in 2021, I'm sorry. But I never received any update nor form document. My current case that I received a receipt number for is pending. But it's showing reviewing process and go schedule biometrics and something. I'm so confused. Please help us up. I'm on thin ice due to an issue I have pending. Okay, Vera, thank you for your question. So I'm a little bit confused as well, because you say that you were approved. I'm assuming you're referring to the processing times for DACA cases that are on 2021. So technically your case should have been approved, judging by the timeline, if I'm understanding correctly. And when you actually check your receipt number, it says that there is something about the biometrics appointment. So that tells me that potentially there was a biometrics notice that was sent out to you that maybe you have never received, that maybe got lost, and that biometrics appointment have never been completed. Which, yes, that can be definitely can be a reason why your case still has not been approved. So what you need to do, you definitely need to reach out to USCIS and let them know that you never received that biometrics appointment, that you need a new one to be scheduled, and you really need to do that as soon as possible before your case is denied, because they can deny your case due to missed biometrics appointment, which kind of sounds like what the situation is in this case. You can do it two ways. If you say that the cases according to the processing times are already outside of normal processing times because they are being approved as of 2021 and yours is still pending, you might be able to reach out using the USCIS case outside of normal processing times form on USCIS website. I'll give you the link for that. But if you're not able to do that, then the best way to do it will be reaching out to the customer service through USCIS, it's going to be difficult. Let's just say that. It's going to be difficult and frustrating. So I'm preparing you for that. But this is really what the best thing you can do. Inquire about case outside process. So this is your number one option, and hopefully that works for you. But again, it might say that, oh, your case is not outside of normal processing times, and not allow you to submit this form. If that is the case, then you will have to reach out through the phone. And it's hard to reach a representative through the phone, but it is possible. It will take a long time, but it is possible. Just be persistent. Always, for everyone, if you're watching these videos on this channel, as I always recommend, be polite, be professional when you're calling any government, whatever government whether you're calling USCIS, whether you're calling whoever it is you're calling. Always be polite, professional. It's no point to argue with them, because you can actually make it worse. But yes, if you can, Vera, that's the best thing to do. The first thing to try is to submit that inquiry, and actually let them know in the inquiry, because they do have last action taken on the case. Right here in this field, you can say that biometrics appointment was scheduled, but you never received the notice, and that way they will know that you have never received it, and that's why you missed it, and that they need to send you another biometrics appointment. So hopefully that works for you. But if not, you're always welcome to come back to this channel, ask additional questions as everybody else. Just make sure not to ask your questions in response to my comment within your comment, because YouTube does not send me those notifications. Just submit it as a separate comment under any of these videos on this channel, and I will be able to see it on this wall and hopefully get to it in a timely manner. So thank you everyone for asking your questions. Hopefully my answers were helpful. God bless, and I'll see you all in the next video.